Well, John, I think a couple of people know you. My name is Anton Sorkin. I am the Director for Law Student Ministries at Christian Legal Society, and I have the distinct honor of welcoming all of you to the first of what we hope to be many Witte lectures. The long title, in honor of this man right here, is the John Witte Jr. Lecture Series on Christianity and Law. Our goal for this new venture is a simple one, to advance the conversation on the integration of Christianity and law. Not simply to look back at the past of those who laid the foundation, like Harold Berman or Brian Tierney, or to simply embrace the present, the people who are writing about this now, like John, like Norman Doe in Cardiff, like Nicholas Aroney in Queensland, but to look also ahead to the nascent generation of authors who will carry on this work in the arduous application of Christian jurisprudence to the modern challenges of man and the state. In front of you, you have a program guide inspired by the painters of the Dutch Golden Age, who I took to embody many of the lessons and instincts I was fortunate enough to absorb in my time at Emory. I found their work to be deeply significant in a connection to the spirit of this lecture. Ideas rooted in the concepts of building something new in the great depictions of the Dutch sea powers painted by the likes of Ludolf Backhausen and Willem van de Velde the Younger, or the concepts of finding balance in the nuances and open countryside affairs of painters like Jan van Goyen and Jacob van Ruysdael. And of course, who can forget the dark and foolishness of the biblical accounts found in Jan Steen's here in the back of your program guide, showing Moses striking that rock the second time and thereby disqualifying himself from entering the promised land. Or the one that most of you are probably familiar with of Christ descending from the cross in the famous work of Rembrandt. Certainly, the coterminous rise of the Golden Age painters and the rise of the Reformed intellectual foundations of the Dutch Reformed Church made my decision an easy one, given John's lineage and intellectual settlement among the greats of the Reformed tradition, from Amsterdam to Geneva. But more than trees, ships, and still lifes, it was the depiction of people that drew me to these painters and ultimately made these painters the perfect embodiment in my mind to serve as the inspiration for this inaugural lecture. And not just people, but in particular women that proved instrumental in so many of the Golden Age masterpieces. And of course, in the work on family law and life from John himself that he has so richly provided to posterity. And perhaps no one captured women better than Johannes Vermeer, who I was told is one of John's favorite painters in this period. That's wrong. Amy's right there. She is responsible for that failure of a line and possibly the whole evening. And one of my favorite paintings by Vermeer is a painting that I got to see myself at the National Gallery of Art. It's a painting that was struck when I first saw it. A painting that you have there in your program guide on page 8 that is serendipitously called Woman Holding a Balance. Before I surrender the podium, I want to read a few lines from Anthony Bailey's biography on Vermeer. This is what he writes. Vermeer's women are individuals who can't be mistaken for anyone else's. Once seen, they can't be forgotten. The painter thwarts our incessant demands for a storyline by freezing the action, by bringing time to a stop for an instant or two, while contemplation exercises its power. Now, I do not have the privilege of introducing our lecturer for tonight, but I do have the privilege, like the quote says, of introducing a woman that I have not forgotten myself since my time at Emory. Someone who has spent at least 6 years hanging out with me and putting up with me for the simple fact I've come to realize that I simply was not smart enough to be annoying. Without further ado, I would like to introduce to you the Chief of Staff at the Center for the Study of Law and Religion at Emory University, who knows John better than most, Amy Wheeler.
Thank you, Anton, for that kind introduction. Thank you for the shout out to women. I love that. Thank you for our Emory women who are here. I love that. We're so pleased to be with you here in DC and extend our thanks to you, to the Christian Legal Society for organizing, hosting, and masterminding this event in John's honor. And thank you for speaking slowly, Anton. You did learn something at Emory. I also thank the Trinity Law School for its sponsorship of this event. Ladies and gentlemen, good evening. Welcome to the John Witte Jr. Lecture series on Christianity and law, and particularly to this inaugural event showcasing his work. It's a privilege to see all of you here, and I thank you for coming. A special thanks to our former students in the crowd, Heather, Jen, Shannon, Jimmy, Rebecca, Andrea, and Sydney. Having you here brings back our good days at Emory Law School and Gambrel Hall. We loved having you there. We love having you here. Thank you to John for your creative skill in inspiring Emory Law students. They watch and they learn from you every day. And thank you to our wonderful colleagues in the crowd. Many of you traveled many miles to be here with us tonight, including Kathleen and Richard, Mark, Daniel, David, Priscilla, and to Peter. One person who's not with us tonight, but who sends their warm regards, is the former president of Emory University, Dr. James T. Laney. Our center was the brainchild of then President Laney, who in the 80s pursued to make Emory a beacon of greater purpose in academia. In his view, a university should inspire and stimulate the kind of moral vision that transcends parochial interests and nurtures the sympathy and understanding necessarily for moral judgment. Dr. Laney writes to John last week, "Congratulations, John, on the Press Club's lecture series in your name. You will set a high bar at its inaugural lecture. You're in the flower of your illustrious career, and I am grateful to be living to see it and to rejoice. Blessings on you and your seminal work." It's my pleasure to introduce and tell you a bit about my colleague and friend, John Witte Jr. John has stood at hundreds of lecterns and pulpits around the world. He's given scores of lectures globally, including most recently the McGuire Lectures at the Library of Congress, the Kluge Chair in Cultures of the North at the Library of Congress, the James W.C. Pennington Lectures at the University of Heidelberg and at Yale Divinity School, the Cunningham Lectures, New College, and at the University of Edinburgh, the Emory Williams Lectures at Emory University, and the McDonald Distinguished Scholars Lecture at Emory University and at Christ Church, Oxford, and the Gifford Lectures in Aberdeen. For more than 40 years, John has led our Law and Religion Center at Emory, where we are dedicated to studying the religious dimensions of law, the legal dimension of religion, and the interaction of legal and religious ideas and institutions, norms, and practices. I'll quote my colleague and friend, Dr. Rafael Domingo, who said, "John's entire life and vast intellectual output have been marked by one fundamental fact. He is first and foremost profoundly Christian." John marks his life and success by saying that, quote, Without the love of my wonderful family members and the love of a gracious God who has blessed us so richly, I would not be who or what I am today. May it long continue." End quote. I hope you made note in Anton's, in this evening's program, Anton's mention of Halvorsen's interaction of law and religion. This treasure of a text, 1974 Abington Press, has been the foundation of many conversations and an instruction book for many a student and academic. I am certain that Hal intended for each of us to consider this book and build upon his ideas around the interaction of law and religion. There is also a mention in tonight's handout of a new work in progress, which is a Festschrift for John's work to date, titled Faith and Law, Law and Faith, Reflecting and Building on the Work of John Witte, Jr. Thank goodness the editors of that large volume added, and the building on his work, because John has much more to produce, and I have some job security as I try to keep his scholarship on time and on track. In 2022, after successfully leading Emory's Law and Religion program for decades, John transitioned to the faculty director of the CSLR and has enjoyed dedicating more time and focus on deep new research and writing, teaching, and public lecturing. John is a Renaissance man. He works continuously without showy or boastful behavior. I'll borrow Sorkin's words when I say, the preeminent scholar of law and religion in the 21st century and the cornerstone of our program at Emory is in this room. Please help me welcome to this stage my colleague, mentor, inspiration, and friend, Professor Dr. John Witte, Jr.
My goodness. Thank you ever so much, Amy, for your wonderful and generous words, heartfelt and deeply appreciated. Amy is one of the unsung heroes in our Law and Religion Center, working assiduously behind the scenes for decades as the chief of staff of our center, as my right-hand person, working on scholarship, working on teaching, and to be together and in the office and engaged in the pursuit of the weightier matters of the law has been a great, great privilege. I'm deeply honored by your work, deeply honored by your words, and I thank you so much for your kindness. Thank you so much, Anton Sorkin, for this remarkable tribute. My goodness, man, all you did was an SJD. I mean, we let you through and you were doing great, and all of a sudden you turn around with remarkable support and tribute, and I'm deeply, deeply grateful. Anton himself is a brilliant scholar of law and religion in the Christian tradition. He wrote a brilliant dissertation under my supervision. He is now leading the ministry for the Christian Legal Society at law schools across the country. And this is a man to be reckoned with in the decades ahead. A wonderful soul, a wonderful person, and I am deeply, deeply grateful to Anton for this special way of recognizing me, for handing me a water bottle, which I've dropped, and for the support that he mustered from our friends at the Christian Legal Society, from Trinity Law School, and from other quarters to create this lectureship. I'm deeply grateful. And John Inazu, thank you so much for taking the time to travel from St. Louis and to shed your light to the conversation this evening. If you have any hard questions that come up in the course of the lecture, please put those to John. Anything small and trivial, I think I might be able to handle, although Amy may have to jump in. But it's a joy to be with you again, my friend, and thank you for your wonderful ministry and leadership in the law and religion field. It's wonderful to have old friends and new students and colleagues whom I've known some for decades, and I'd love to be able to sit this evening and talk about each of you and to brag on you and to say how much I appreciate your contribution to my life and to the world of scholarship that we both inhabit. But I want to single out two people, if I may, with no offense to those that I have to pass over. The first is my dear bride, Eliza Allison. She has been my indispensable anchor and advisor and advocate for many decades. And we have built a wonderful life together, which has been the absolutely most important thing that's ever happened to me. A great, great blessing. She also, for 20 years, worked in our Law and Religion Center, single-handedly initially, working to build up the work in law and religion and building the staff and building the students, mentoring some of the students that are here. And then our grandchildren came, and she found a higher vocation and has stepped down. And second, I want to recognize my dear friend and brother, Peter McDonald. Peter McDonald, the president and the chairman of the McDonald Agape Foundation, succeeding to that role from his father, the late, great Ambassador Alonzo L. McDonald. Al and Peter and his family and the Family Foundation have been uncommonly generous in collaborating with us on our work in law and religion, on sponsoring fundamental scholarship on these great matters of law and faith, and helping us create a global network of law and religion scholars, hundreds of volumes and articles that are important parts of the contribution to the next generation of leaders in the field whom we're constantly having in mind. Peter, thank you so much for taking the time to be here, and thank you to Marie, your bride, for letting you go for the evening. I bring you great news of good joy. Good news of great joy. Put it either way you want. Religious freedom has reawakened in America, and the loudest wake-up call has come from the United States Supreme Court down the road. Only a dozen years ago, American religious freedom was in trouble in several states and federal circuits. There, religious parties were excluded from state scholarships and vouchers and public programs and benefits. Old religious monuments, art, and books were targeted for removal as badges of bigotry and Christian favoritism. State civil rights commissions were imposing massive sanctions on conscientiously opposed vendors for not servicing same-sex weddings, religious pharmacists for not filling prescriptions for abortifacients, religious hospitals for declining procedures affecting sex and procreation, religious charities for discriminating in their family services. Some critics and legislatures were calling for religious communities to be stripped of their tax exemptions, marriage solemnization rights, and social service contracts. Several states enacted new anti-Sharia measures and other anti-Muslim policies. Throughout the late 80s, 90s, and 2000s, the Supreme Court sat largely quiet, leaving most religious freedom questions for states and legislatures to work out in accordance with the court's new devotion to federalism and separation of powers. There were many reasons for this turn against religion and religious freedom. Worries about militant Islamicism after 9/11, massive sexual scandals and cover-ups within some churches, media exposures of the luxurious lifestyles of some religious leaders, blatant political gamesmanship by some faiths. A stronger reason still was that some religious traditions opposed the rapidly emerging constitutional rights of same-sex liberty, equality, and eventually marriage. Some faiths also opposed old constitutional rights to contraception and abortion. Strong critics in the academy and the media now branded religion as an enemy of liberty and decried religious freedom as a dangerous and outmoded constitutional luxury. All that has changed dramatically. While loud criticisms of religion continue to clatter in the media and in the law reviews, the U.S. Supreme Court has led a great awakening of American religious freedom. In more than two dozen cases over the past decade, the court has used both the First Amendment and federal statutes to strengthen the rights of religious organizations to make their own internal decisions about employment and employee benefits. It has held that government aid to religious education is not only permissible, but sometimes required. It has struck down several laws that discriminated against religion, that penalized parties for taking religious stands, or that coerced parties to act contrary to their conscience. The court has insisted on both individual and corporate exemptions from general laws that substantially burdened religion. And the court has supported strong new protections for religious rights of prisoners and even allowed the collection of damages in certain religious freedom violation cases. These 24 recent Supreme Court cases signal a decisive return to America's founding axiom that religious freedom is the first freedom of our constitutional order, not a second-class right. The 18th century founders' vision was that religion is more than simply another form of expression and association. It deserves special constitutional treatment. The founders thus placed the guarantee of freedom of religion before the freedoms of speech, press, and assembly in the First Amendment. All peaceable exercises of faith, whether individual or corporate, public or private, traditional or new, popular or reviled, properly deserve the protection of the First Amendment. The current Supreme Court has again embraced this traditional view of the First Amendment with alacrity. The court has also embraced the traditional view that the First Amendment provides an interlocking and integrated shield of religious liberties and rights for all. The First Amendment Free Exercise Clause outlaws government proscriptions of religion, government actions that unduly burden the conscience, that unduly restrict religious expression, that discriminate against religion, or invade the autonomy of churches and other religious bodies. The First Amendment Establishment Clause, in turn, outlaws government prescriptions of religion, actions that unduly coerce the conscience, mandate forms of religious exercise, discriminate in favor of religion, or improperly ally the state with churches or other religious bodies. The First Amendment thereby guarantees those 6 constitutive principles of the American experiment: liberty of conscience, freedom of exercise, religious pluralism, religious equality, separation of church and state, and no establishment of religion by law. In the 1940s, the U.S. Supreme Court had confirmed all these founding principles of religious freedom when it opened the modern era of case law. But in the 1980s and 90s and early 2000s, the court gradually reduced the First Amendment to a mere guarantee of state neutrality toward religion. That provided some protection, but not much. Today, the court offers far more principled and far more robust protection of religious freedom. The court's recent cases not only revive the founders' vision, they also offer fresh insights and accents that provide a more integrative approach toward religious freedom protection going forward. 5 distinct teachings are worth highlighting. One teaching of the court's recent cases is that a regime of religious liberty must respect historical democratic judgments. The court has used arguments from history and tradition before as parts of broader rationales for upholding traditional religious tax exemptions or Sabbath day laws or legislative chaplains' prayers, all of which were commonplace in the founding era. In the 2014 case of Town of Greece versus Galloway, however, the argument from historical democratic judgment became the key basis for upholding a local community's decades-long practice of offering prayers, led by sundry invited local clergy to open its town council meetings. A local taxpayer thought this constituted an establishment of religion. The court disagreed. The First Amendment must be interpreted by reference to historical practices and understandings, Justice Kennedy wrote for the court, particularly those that have withstood the critical scrutiny of time and political change. A test, the court said, that would sweep away what has long been settled democratically, would create new controversy, and begin anew the very divisions along religious lines that the Establishment Clause sought to prevent. The 2019 case of American Legion versus American Humanist Association used similar logic. That case featured a large Latin cross that had been privately erected in 1925 as a memorial for local soldiers who had died in World War I. But it now stood at a prominent intersection of 2 major roads that had accreted in the ensuing decades. The American Humanist Association thought this major Christian symbol constituted an establishment of religion and should come down. A 7-2 court, led by Justice Scalia, rejected this claim. The court agreed that the cross is a poignant Christian symbol. But this Latin cross, Alito wrote, in place for nearly a century, had taken on independent value as an embedded feature of the community's landscape and identity. For some, the cross was a symbolic resting place for fallen soldiers. For others, it was a place for the community to gather and honor all veterans and their sacrifices for our nation. For others, it was just a familiar historical landmark. When the passage of time, Justice Alito wrote, imbues a religiously expressive monument, symbol, or practice with familiarity and historical significance, that gives rise to a strong presumption of constitutionality. The upshot of these and other recent cases is that the First Amendment does not give a disgruntled taxpayer a heckler's veto over long-standing democratic decisions a local community took to create and maintain a religious symbol or ceremony. Change may come, but that change must come by legislation and not by litigation. Many areas of American law respect the power and passage of time. Historical preservation and zoning rules grandfather older uses of property that do not comport with current uses. Adverse possession and prescription rules of property allow for an open, notorious, and continuous use of a property to vest in the user. Statutes of limitations and res judicata rules promote finality and closures of old disputes. The equitable doctrine of laches bars claims from parties who sit on their rights too long. Similarly, in constitutional law, tradition effectively serves as a null hypothesis, requiring that a challenged practice or policy be overcome by strong constitutional arguments rather than simply discarded by simple invocations of principle. As Oliver Wendell Holmes once put it, if a thing has been practiced by common consent for 200 years, it will take a very strong case to unearth it. This argument from history and from tradition has been enough to mark and to support the continuation of chapels and chaplains and legislatures and military bases, state prisons, public hospitals, or embassies. To maintain old decalogues and menorahs and creches and ceremonial Indian mounds in state parks. Religious figures, verses, and sayings on public monuments, memorial crosses and stars and other religious symbols in state cemeteries, religious iconography on official coinage or stationery, ceremonial recitations of oaths and proclamations and pledges that invoke the name of God and other religious language. So long as private parties are not coerced into participating in these or endorsing these religious icons, and so long as government strives to be inclusive in their depiction and representation, there is nothing wrong with a democratic government reflecting and representing the traditional religious values and beliefs of its people. Yes, some old traditions, no matter how venerated, eventually do have to go when they no longer represent a community's values, as the nation witnessed with the removal of Confederate flags from Southern Capitol buildings, or the renaming of structures built on the backs of slaves and named for their abusive masters. But many old, innocuous, and avoidable religious symbols and practices can and should stay. That's the court's position, and I think they're right. A second key corollary teaching of the court's recent cases is that government may not coerce parties into supporting or participating in religion, even old and venerable religious traditions and practices that may have won widespread democratic approval. This is a time-honored First Amendment teaching. The law's absolute in forestalling compulsion by law of the acceptance of any creed or practice of any form of worship, wrote Justice Roberts in Cantwell versus Connecticut, the first case that opened the modern era of religious freedom. Later free exercise cases thus struck down compulsory flag salutes and mandatory recitations of the Pledge of Allegiance and state-administered religious testos as forms of religious coercion. Later free speech cases held repeatedly that government cannot induce or coerce parties to express themselves contrary to their religious beliefs. That proposition, ancient as it is, informed the court's most recent free speech case of 303 Creative versus Alanus, which protected a website designer's decision not to include wedding services and wedding service information to same-sex couples. Government can't tell you what to put on your billboard. Government can tell you what to put on your website. And later, Establishment Clause cases insisted that young, impressionable public school students under mandatory school attendance orders could not be coerced to participate in religious teaching and prayers and Bible readings or religious symbols as part of their classroom or curricular experience. Even a one-time invocation at a public middle school graduation ceremony was deemed coercive. The court's recent cases have confirmed this prohibition on religious coercion, but it has also raised the threshold on when freedom from religious coercion can be successfully claimed under the Establishment Clause. In Town of Greece, the court made clear that the brief, solemn, and respectful prayer offered by an array of local pastors before the town council began its meeting was not religious coercion. It was, the court said, simply a way to lend gravity to public proceedings and to acknowledge the place religion holds in the lives of many private citizens. No citizens were coerced to compel or participate in the religious observance. They could simply skip the brief prayer before entering the sanctuary or the meeting place, or simply ignore any prayer they may have heard with impunity. Self-help was the better course of action, the court said. Yes, some secular citizens might be offended by the very presence of these old religious ceremonies, the court admitted, just as some religious citizens might be offended by various new secular and sometimes anti-religious messages they have to hear. But offense does not equate to coercion, Justice Kennedy said for the Town of Greece court. Adults often encounter speech they find disagreeable, and an Establishment Clause violation is not made out anytime a person experiences a sense of affront from the expression of contrary religious views. Blasphemies of all sorts, we all must indulge and endure as a cost of free speech for all. 5 years later, Justice Gorsuch made a similar argument in the lengthy concurrence of an American Legion. Indeed, he argued, without proof of actually being religiously coerced, offended bystanders should not even have standing to press Establishment Clause cases against government actions or expressions that offend them. In a large and diverse country such as ours, offense can easily be found, said Justice Gorsuch. Really, most government actions probably offend somebody. No doubt, too, that offense may be wise, sometimes well taken, even essential. A recourse or disagreement and offense does not lie in federal litigation. The offended viewer must avert his eyes, cover her ears, or vote for someone else. A third key teaching of the court's recent cases is that religion deserves not just state neutrality, but equal treatment and equal protection by government. The court has not formally rejected the 1990 case of Employment Division versus Smith that said that neutral, generally applicable laws are constitutional no matter how crushing a burden they might impose upon religion. But the court now judges any differential treatment of religion as fatal religious discrimination under the First Amendment. And the court has repeatedly rejected government's argument that differential treatment of religion is needed to avoid establishing religion. Disfavorable treatment of religion by government is unconstitutional discrimination, the court says, full stop. This focus on equality over neutrality is clearest in recent Supreme Court cases on state aid to religious education. Such aid has long been a vexed topic. Before 1940, 35 of the then 48 states had passed state constitutional prohibitions on government funding of religious education. And after 1940, the Supreme Court struck down many forms of direct and indirect aid to religious schools and parents and children alike as violations of the First Amendment Establishment Clause. That has now changed dramatically. The court now holds that state aid to religious education is not only permissible under the Establishment Clause, but sometimes required by the Free Exercise Clause to ensure equal treatment of religion. In the first main case, Trinity Lutheran Church versus Comer in 2017, the state excluded a church school from a state program that paid for rubber resurfacing of school playgrounds. The church school, the Lutheran church school, in fact, applied and qualified for the funds, thinking that Lutheran needs need to be protected from abrasion just as much as everybody else's. But the state denied them the funds because its state constitution prohibited funding religious education. That had long been the standard response to these cases. The Trinity Lutheran Court saw this for the first time as a violation of the Free Exercise Clause. The church school was denied a grant simply because of what it is, a church, said Chief Justice Roberts. State laws that impose special disabilities on the basis of religious status alone are permissible only if the state has a compelling interest for so doing and a general concern, even based in a state constitutional text, about avoiding an establishment of religion this way is not compelling enough. The court repeated this reasoning 2 more times in Espinoza versus Montana and again in Carson v. Macon with the repeated argument that if you're going to give funding and opportunities to receive funding to private entities, religious and non-religious folk need to be treated alike. The recent court had also used the free speech equality principle to uphold private religious expressions. In the 2022 case of Shurtleff versus City of Boston, for example, the city had allowed nearly 300 private groups over the prior 15 years to gather in the City Hall Plaza for their own events and to fly their own flags on one of the city poles during those events. When Shurtleff and his Christian group sought to use the plaza, the city gave them the use of the plaza but would not let them fly their Christian flag for fear of violating the Establishment Clause. Shurtleff claimed religious discrimination under the Free Speech Clause. And now, remarkably, a 9-0 court, led by the liberal titan, my old professor, Justice Breyer, agreed that Boston had committed viewpoint discrimination against religion. The court's insistence on equality also guided its review of free exercise challenges in the myriad COVID regulations that placed restrictions on public gatherings, movements, and activities. Under its emergency docket, the court upheld such restrictions when they fell equally on religious and non-religious parties, but enjoined them when religion was treated differently. In the 2020 case of Roman Catholic Diocese versus Cuomo, for example, Catholic and Jewish groups challenged the New York governor's order that created different tiers of restrictions on public gatherings depending upon local pandemic levels. The plaintiffs argued that the governor had made disparaging remarks about the Orthodox Jewish communities, and he had gerrymandered the restrictive zones to ensure that they covered these religious neighborhoods. Moreover, these regulations placed no capacity limits on purportedly essential businesses in the same zones, including acupuncture facilities and manufacturing plants. This law singles out houses of worship for especially harsh treatment, the court said, and issued an injunction. Similarly, in the 2021 case of Tandem versus Newsom, public health orders prevented more than 3 households from gathering for worship while allowing larger house gatherings for business meetings and social parties. The court again struck this down, now citing the, quote, clear rule that government regulations are not neutral and generally applicable when they treat any comparable activity more favorably than religious exercise. A fourth teaching of these cases is that sometimes equality is not good enough to guarantee religious freedom. In those cases, both legislative and judicial exemptions from compliance with general laws are needed. This, too, was traditional law. Already in the 18th century, the founders recognized that exemptions provided parties who had religious scruples with a necessary oasis of nonconformity, a space to follow the dictates of their conscience or the commandments of their faith community. The founders thus granted various exemptions from religious taxes and oath swearing in military service. And these exemptions and others continued into federal and state laws in the 19th and 20th centuries. In the 1963 case of Sherbert versus Werner, the court went further to create judicial exemptions to relieve parties from substantial burdens on their faith imposed by otherwise perfectly appropriate statutes. And courts used these judicial exemptions to give relief to Saturday Sabbatarians and Amish ascetics and Jehovah's Witnesses and pacifists and similar parties. The 1990 Smith neutrality test largely closed the door on these judicial exemptions. And this has led to an explosion of legislative exemptions at the federal and at the state level, which the court has assiduously enforced. The court, for example, interpreted the Religious Freedom Restoration Act to grant exemptions to Hobby Lobby, arguing that a closely held business corporation can get a partial exemption from the Affordable Care Act that mandated employees' insurance for abortifacients, contrary to the owner's religious scruples about the sanctity of life. The court interpreted the Religious Land Use and Institutional Persons Act to provide protection for the religious worship of prisoners, including Muslims, to exempt them from grooming requirements that burden their religion, and to permit chaplains to pray and lay hands on them on the day of their execution. The court has pressed civil rights prohibitions on religious discrimination to protect a Muslim job applicant from a prejudicial hiring and a Christian Sunday worker from a retaliatory firing. In a world of growing religious pluralism and anti-religious animus, religious freedom exemptions are essential, even if they're always controversial. What has made them more controversial of late is when majority faiths seek judicial exemptions after failing to get them from the legislature. Judicial exemptions used to be justified as a suitable refuge for religious minorities from the tyranny of the legislative majority. They're now being pursued as well by majority faiths. What has also made exemptions more controversial is when granting the exemption causes third-party harm to others. In cases like Masterpiece Cake Shop, dealing with the baker who refused to bake a cake, and Creative 303, the website designer who refused to advertise same-sex wedding services, the harms imposed by the exempt conduct may be real to the victims and their dignity, but they're more attenuated when there are alternative bake shops and website designers around, especially if the cases look like they're staged. But when parties are exempted from more vital services, that becomes more problematic. A final teaching of these recent cases is that the principle of separation of church and state is no longer the secular be-all and end-all of the First Amendment, as it had been taken to mean in the last half of the 20th century. Separation of church and state, correctly understood, remains an essential principle of First Amendment religious freedom. And that principle needs to be retained, particularly for its ancient insight of protecting religious communities and organizations from political intrusion and interference. Today, as much as in the past, government officials have no constitutional business interfering in the internal religious affairs of religious groups, or dictating forms of worship, or prescribing doctrines and creeds and practices for communicants and citizens. The 2012 Hosanna Tabor case and the 2020 Lady of Guadalupe cases that protected churches and church schools in their autonomy in making decisions about their own membership is a reflection of that. And the Hobby Lobby and As subsequent cases underscore that government cannot compel religiously chartered or grounded institutions to offer benefits or services that violate their core claims of conscience. But the recent court has retreated from earlier insistence on a high and impregnable wall of separation between church and state, whose slightest breach would said to trigger an Establishment Clause violation. Not only was this earlier teaching based on selective history and suspect jurisprudence, as Daniel Dreisbach, my friend and colleague, has proven dispositively in a number of writings, but absolute separation of church and state is impossible to put into practice today. Ours is not the distant night watchman state, content to limit its activities to defense and policing and road and bridge maintenance, and maintenance, of course, of the postage. Today's modern welfare state is an intensely active and ambitious sovereign from whom complete separation is impossible for any religion that forms even the smallest community and peeks out of its cave or prayer closet. Few religious bodies, and indeed few believers, can now avoid contact with the state's pervasive network of education and charity and welfare and healthcare and family construction, zoning, workplace taxation, and sundry other regulations. Today's governments not only enact and enforce laws, they also make grants and extend loans and confer licenses and enter contracts and control much access to the civic and economic arenas. And so both confrontation and cooperation with the modern welfare state are almost inevitable for any organized religion. When a state's regulation imposes too heavy a burden on a particular faith, the Free Exercise Clause should provide a pathway to relief. When a state's appropriation imparts too generous a benefit to religion alone, the Establishment Clause should provide a pathway to dissent. But when a general government scheme provides religious groups and activities with the same benefits accorded to all other parties and all other eligible recipients, or when government cooperates with religious agencies to accomplish secular purposes that serve the common good, Establishment Clause objections now are unavailing. A few concluding reflections. Constitutions work like clocks, American founder John Adams reminds us. And to operate properly, their pendulums must swing back and forth, and their operators need to get wound up from time to time. We have certainly seen plenty of constitutional operators get wound up of late about religious liberty, and we have witnessed wide pendular swings in free exercise jurisprudence. But despite the loud calls from the academy and elite media that continue to dominate the headlines, the United States Supreme Court has ended the 3-decade-long swing of cases away from religious liberty protection and is now leading a strong pendular swing back. Since 2011, almost every one of the 24 Supreme Court cases on point advanced the cause of religious freedom. And these cases have been echoed and extended in dozens of lower federal courts. The court has not always produced clean and clear and clockwork logic, nor settled on a grand unified theory that some of the justices and academics have called for. But it has produced a long, hard swing in favor of religious freedom, even if sometimes wobbly. This has been a good movement for modern democracy. Religion is too vital, a root and a resource for democratic order and rule of law to be passed over or pushed out. Religious freedom is too central a pillar of liberty and human rights to be chiseled down or pulled away. In centuries past, and in many regions of the world still today, disputes about religion and religious freedom have often led to violence, sometimes to all-out warfare. We have the extraordinary luxury in this country of settling our religious disputes and vindicating our religious rights with patience, deliberation, due process, and full ventilation of the issues on all sides. We would do well to continue to embrace this precious constitutional heritage and process and take it seriously. As this process continues to unfold, it is essential, in my view, that the full range of religious freedom principles remain in operation. Liberty of conscience, freedom of exercise, religious pluralism, religious equality, separation of church and state, and no establishment of religion by law. Religious freedom norms should not be diluted into neutrality or equality norms alone, nor weakened by too low a standard of review or too high a law of standing. It is essential that America addresses the glaring blind spots in our religious liberty jurisprudence, particularly the long and shameful treatment of Native American Indian claims and the growing repression of Muslims and other minorities that are not being addressed very well at all at the local level. It is essential that we show our traditional hospitality and charity to the sojourners in our midst, migrants, refugees, asylum seekers, and others, and desist from some of the outrageous nativism and xenophobia that have marked far too much of our popular and political speech of late. It is essential that we balance religious freedom with other fundamental freedoms, including sexual and same-sex freedoms, and find responsible ways of living together with all of our neighbors, even if we need high fences, and desisting from mutually destructive strategies of defaming and demonizing and destroying those who hold other viewpoints. It is essential that religious liberty advocates not overplay their hands. It is often extreme cases that trigger a reverse pendular swing and short-term victories that push the court to a reductio ad absurdum in one case produces strong backlash that can take a generation to stop. It is essential that majority Christians today, who have won most of the recent cases, remain gracious in victory, especially to those who do not share their faith. This is not only the heart of the golden rule, doing unto others as you would have done to you, but Christians must be aware that soon they will be in the minority. While religious freedom is rising, religious allegiance, particularly amongst Christians, is falling dramatically. We need to remember the rules that we craft now and the case precedents we produce will govern the religious liberty of our grandchildren. Catholics in particular, who now command enormous political power, would do well to remember that it was less than a century ago that Catholics were a hated and persecuted and despised minority in America. That day could return. Doing unto others what is loving and just is not only the right thing to do, but expedient as well. It is essential that we treat religious freedom as a precious gift of God to protect, not a prerogative of a political party to brandish. Put not your faith in princes, the Bible tells us, and by extension, put not your religious freedom in the hands of politicians, or reduce it to a mere political plaything during political campaigns. And finally, it is essential that we Christians in particular use our religious freedom wisely to return to our most cardinal callings of preaching the word, administering the sacraments, catechizing the young, caring for the poor and needy, and prophesying against injustice. Like all other institutions, Christian churches have not been immune to the vices of their members and their leaders. Think of the clerical abuse of minors, the gross embezzlement of tithes and gifts, the degradation and mistreatment of women, indifference to the poor and the needy, a lack of compassion in matters of sex and sexual orientation, racially and economically segregated congregations, aversion to immigrants and foreigners. Our failure as Christians in some quarters to live up to our own truths and values rightly undercuts our moral authority in the eyes of others and rightly raises skepticism about the power and provenance of religious freedom. Contrition and confession, restoration and reformation are the better course. Martin Luther King Jr. once said that the church is not the master or the servant of the state, but rather the conscience of the state. When the roadhouses are in good order, churches are well situated to play this prophetic role. As Dr. King says it again, if the church will free itself from the shackles of a deadening status quo, if the church will repent of its failings and come back to its great historic mission, if the church will speak and act fearlessly and insistently in terms of justice and peace, it will enkindle the imagination of mankind and fire the souls of men, imbuing them with a glowing and ardent love for truth and justice and peace. Men far and near will know the church as a great fellowship of love that provides light and bread for lonely travelers at midnight. Thank you very much.
Anton, thanks so much. This is a real privilege to be here. I want to say, Anton, you've got one more job, which is you've got to tell me when there's time for one more question, or else we're going to be here for a long time. John, it's such an honor to be with you here, and I just want to commend everyone here, not just your example and role model and witness as a scholar of law and religion, but also as a Christian in the legal academy and what that's meant to a lot of people who come after you. So thanks for your slow and steady and faithful witness there. I have lots of questions, but I will contain myself to a appropriate amount of time before turning it over to you. But I largely agree with your analysis of free exercise doctrine and where we are. We are in a place of strong religious freedom. Things have improved in dramatic ways, even though we have people in the country saying, right, we're under attack. I think there's strength in the doctrine, and that matters, and that needs to be stated. I do wonder, though, about some of the demographic changes we've experienced. We are a country today that has a much more pluralistic citizenry than we did 30 years ago at the time of Smith, certainly at the time of the founding. So, and I think especially of the role of non-believers in that and how non-believers affect the polity, but also the doctrine. So if I'm a non-believer, if I'm an atheist, what's in it for me with free exercise? Why wouldn't I just oppose this special exemption for people who believe in something transcendent that I reject as a first principle? And how, as the demographic of non-believers grows, how do we continue to assure support, not just constitutionally, but culturally, for free exercise?
Yeah, so it's interesting that one of the first cases dealing with an exemption, a 1961 case called Turcaso v. Watkins, actually involved an atheist who was making a free exercise claim to be excused from or exempt from compliance with a religious test oath that was still being administered for a modest position that he was pursuing in the state of Maryland. And he made the case to say, on the one hand, that's an establishment of religion. God is being signaled out in this test oath, and I have to attest to God's existence and swear my veracity on the basis of God. But his other claim was that I have a free exercise right to be free from coerced faith. And the Supreme Court largely weighed the second argument more strongly and came to the conclusion that, yes, this atheist needs to be given free exercise protection from being coerced into religious practice that was contrary to his beliefs. The court there worked on the assumption, even in the midst of the Cold War, even in the midst of all the rah-rah, they are the atheists in the Soviet Union and we are the Christians here, the court recognized that atheism could be viewed as a religion. It recognized that it's an affirmative belief in the non-existence of God, and it deserves protection as a form of faith. As an early case, and subsequent cases have been quite generous in trying to expand the boundary of who counts and who does not count within the ambit of religious freedom under the Free Exercise Clause, amongst others. The harder question is when we move toward what the European Court of Human Rights and other instruments across the Atlantic talk about the freedom of thought and conscience and belief. And we have chosen in this country to draw a distinction between the freedom of religion qua religion, however difficult it is to find that, and other freedoms of thought, conscience, and belief that folks can enjoy under the Free Speech Clause or under the liberty provisions of the 5th and 14th Amendment and more. And the growing pluralism in the United States, on the one hand, tempts us to say we must be generous in according religious freedom to everyone and giving them the special goodies, including exemptions that obtain in the event of finding a religious freedom claim. But at the same time, recognizing that if everything can become a religious claim, ultimately we have balkanized the polity to the point of ungovernability. And so I think the founder's instinct was to say there is a line between religion and non-religion. There is generous freedoms to the expression and assembly and other activities by the non-religious who can continue to enjoy them. And today, as much as in the 18th century, that is an open invitation to them. The groups that are non-religious do not have the countervailing Establishment Clause worries about being funded and supported. There's not the limitation, the kind of reverse magnetic poles that the Free Exercise and Establishment Clause counterpose for the sake of creating as deep a channel of religious freedom as others. But there is outside the channel an ambit of the non-believer, and that non-believer can pursue her or his or their claims under other protections, statutory and constitutional. And I think the founders would agree with that. I think the polity is better served by recognizing, as James Madison said in Federalist number 10 and 51, factions are good for the polity rather than bad for the polity. The issue is whether all those factions have to be called religious, and I dare say they don't need be.
Let me flip it to the Establishment Clause side. And as you were summarizing American Legion in Town of Greece, you use the phrase historic democratic judgments. I want to focus on the word democratic.
Yep.
The American Legion Cross is erected in 1925, 5 years after women get the right to vote. African Americans effectively can't vote. 15 years later, my people are locked up during the internment. So what is democratic in 1925? And can we even use that term coherently to describe a tradition that shut people out? And I think this becomes especially relevant with the monument cases, where the historic monuments are almost uniformly Protestant of some sort because the cultural and legal forces supported Protestantism and excluded others. So as we look to this kind of new test emerging from the court, is there a problem inherent in the description of democratic, and is there a weakness to the theory?
Yeah, I think there is a troubling aspect of this democratic judgment because it in many ways kicks the ball to the other branches of government, number one. Number two, yes, of course, democracies in the past were far less representative of vast constituencies in the population than they are today. And that may well result in the proper legislative judgment that we have to take the cross down, that we have to remove the Ten Commandments display, that we have to desist from putting up the creche, that we should, if we're going to put up a religious symbol, recognize that other religious symbols and non-religious symbols might well be a better democratic representation of values. I think that clearly is the case. There is no question that the court's appetite for upholding religious symbols has been almost principally directed to the protection of traditional religious symbols and traditional Christian symbols, and almost most of them are in the formulation of Protestant renditions of the Ten Commandments, Protestant ways by which we depict the cross, Protestant ways by which we acknowledge God. And I think one of the court's response would be, and I think I agree with the court's response of this one, would be, if you don't like it, take it down. And there's no free exercise violation if you do take it down. You have to bear the political heat, but we would rather have that be done in a new, more robustly representative democratic decision-making than be done by 9 geezers in black bathrobes who have a limited record based upon what was pled below.
You also
So
mentioned
talk about undemocratic. I mean, the court doing it in lifetime tenure, a little more representative now of the demography of the nation than it used to be, but a very undemocratic court making democratic judgments that are different from the democratic judgments that were made 50 years ago, 100 years ago, is deeply troubling.
In the discussion of the Establishment Clause cases, you also mentioned the notion of offense. And I just agree with you completely that offense is so subjectivized that neither in Establishment Clause nor free speech doctrine is there going to be a coherent doctrine around offense. But I was thinking that maybe there's something different going on in Town of Greece in particular. So Justice Kagan, in her dissent, posits, what if you are the atheist going before the town council for your zoning variance or whatever it is, and you're standing there and everybody prays in front of you and you are compelled to pray? Is there something more going on than just offense where the majority culture backed by law asks people to comply in a certain way that might be against their own conscience?
Yeah, I mean, you're hypothesizing facts that weren't in evidence, although they're interesting if they would be. I mean, if a person in
Justice
fact,
Kagan was,
if a person, yeah, but she was hypothesizing facts too, with all due respect to my old classmate. The persons do not have to be there in order to listen to the prayer. They can come in later. Persons can come in and they can cover their ears. Persons are not asked to recite the prayer. They're asked to listen to the prayer respectfully. The prayer itself is a diminished 30 to 40 second throat clearing. It's not a robust rendition of the Lord's Prayer or a more specifically typecast version of any particular faith tradition's prayer. The increasingly pluralistic representation of the people giving the prayer made it easier for people to begin to say, well, I may be offended this week, but won't be offended next week. And you got to remember that in the course of those heated town council meetings, people are going to be taking the Lord's name in vain many times. People are going to be blaspheming against Christian truths and other people's truths. It's a necessary cost of being in public. And it's not a condition for political participation. It is not an essential first step in being able to press one's case before the town council. And it's a solemn, brief, respectful prayer, as the court characterizes it in the majority opinion of Town of Greece. I have a lot more trouble when it is a pervasive prayer. For example, some of the case law after Town of Greece deals with people sitting in school boardroom settings or sitting in the faculty lounge at a school, and they are the decided religious minority. And day after day after day after day, the principal in their school continues to pray the Lord's Prayer in offense to their faith, not giving them a chance to offer their own prayer, not allowing them to come in late, insisting upon having the teachers' union or teachers' meeting at that exact time. That's a lot more problematic. But one time to try to get your little zoning ordinance fixed or to get permission to be able to put up an interesting little shed on your lot and showing up and hearing 30 seconds, I don't think that is worthy of an Establishment Clause violation, with all due respect to Justice Kagan.
To Justice Kagan. Let's go back to the
You, of course.
Let's go back to the symbols. And this, I think this is actually more of a theological question than a legal one, but the current doctrine around, say, the cross gets a pass because its meaning has become watered down. Kim Kardashian wears it and everyone thinks it's just a symbol of war or sacrifice. But shouldn't, as Christians, we be very worried about the cross being constitutionally protected because it means nothing?
Yeah, I mean, that's a deep concern. I would much prefer not to have crosses in public lands. I would much, in cemeteries, sure, but not on public lands. Not these, start putting up a brand new big cross and saying this is allowed now under the Establishment Clause, to my mind, begins to smack of blasphemy. I would rather have the place where my Lord sacrificed himself on behalf of all of us I would rather have that as something properly in a worship setting rather than in public. But having made historical decisions about the propriety of that, and recognizing there are different views about what the theology of the cross is in public and private life, I still think the leaving it up is okay. And I would prefer the current logic of the court, which says, look, it is a cross. Christians recognize it a cross. We're not going to deny it's a cross. But it has all these other additional phenomena that are going to give it constitutional acceptability, is a much better logic than the old days, where the Supreme Court in the 1980s and 1990s basically looked at a cross and continued to kind of make it bleached and bland enough to pass constitutional muster, but ultimately de-theologized it to the point of blasphemy. That was worrisome, right? When prayers become simple invocations and when crosses simply become interesting architecture, that becomes a problem in my view. And the cheapening of it, to my mind, encourages me as a citizen and a believer to say, keep your crosses in your churches at home. Put them on your front lawn if you want, but don't let the government hijack them for their own political ends.
I'm going to limit myself to one more question, and then
That
I'll
was
turn it over to
inflammatory
you.
enough to get everybody excited.
Yeah, I'm reading the room here. That's right. But there was one case you didn't mention, and I couldn't help think of it. I don't know why, but maybe because the Christian Legal Society is sponsoring this. Christian Legal Society against Martinez, which is the 2010 5-4 decision that denied, not under free exercise, but under other constitutional reasons, denied the legal recognition of the student CLS chapter at a public law school at Hastings College of the Law. This is an important decision. It's still on the books. I have my own theory that had Kagan replaced Stevens by the time of that decision, it would have flipped the other way. We certainly have a different court today, though, from 2010. And the doctrine of Martinez seems unbelievably unstable compared to the rest of free exercise law today.
Yeah.
So why is this case still there? And where do you see it going in the coming years?
Yeah, so I see the Christian Legal Society versus Martinez case as the last case in the era before this new Great Awakening. There's a very strong case. It was a disputed case. It was a 5-4 case. It put Justice Ginsburg and Justice Alito in really powerful rhetorical counterposition. And it was a difficult case because the facts were so difficult to discern from the record below and how the court took those facts. Was it really an all-comers policy that was being universally applied against all parties, and that the women's group, the Women's Law Students Association, needed to include men, and if they didn't, that was in gender discrimination, and the black law students needed to include non-black law students, otherwise they were engaging in racism, and the young Democrats and the young Republicans and the tree huggers and the Karl Marx huggers all had to include everybody else. I mean, the reality was we had 50-odd groups who had organized for all kinds of purposes, had criteria, either tacit or express, about membership, and had never been subject to any kind of civil rights action by the state or by the University of California, a public university that enforces state law. And now suddenly the Christian Legal Society comes along, advertises its long-standing criteria of membership, membership, and that criterion insists upon abiding by Scripture and not living a quote-unquote unrepentant homosexual life. All of a sudden that became a problem, and now is being applied to them for the first time. Now, tabula rasa, if there had not been this history, and this was the first violation that the University of California Hastings College of Law saw, yes, it would be an easy case to say, this is a group that's out of step with the state non-discrimination norms that prohibit discrimination against, among other folk, same-sex or LGBTQ parties. I forget what the nomenclature of the California statute was at the time. But that was not the case. And the argument to say that this was a group that was being singled out because it was politically incorrect or was politically out of step with California had a little bit more palpability when there was a 15-odd year history before, where all the other groups that engaged in discrimination, contrary to the express provisions in the California Civil Rights Act, could go with impunity. So that's kind of the difficulty of the case. The stability of the case, I think, is deeply worrisome. I think it's been a case that's now been distinguished to its own bottom. I think increasingly today, We are not finding the same application of that precedent outside of the Ninth Circuit. Still, I think, still in the Ninth Circuit, you see a little bit of it. But it's I think, a case that has forced more groups to camouflage and contort themselves to fit within the Civil Rights Acts rather than fight for recognition at state law. And it's also kind of created a two-tier system where the state holds out a bunch of benefits. You can get extra goodies, you can get billboards, you can get electronic access to things at the university, you can get various kinds of privilege to get to forums, and all the other groups, you guys can meet at Denny's down the road, or you can meet at Dunkin' Donuts or in somebody's dorm room, but you don't get all these goodies. And many groups have simply said, rather than fighting the battle and creating another $1 million case, maybe the better thing to do is simply fly under the radar and be a house church. We've done this before, 2,000 years ago.
I kind of want to follow up and know what the Karl Marx huggers are, but I'm going to limit myself there. Questions from you.
The Young Marxist Society, as I recall.
And I want to go ahead and mention, because John brought it up, one of the plaintiffs of Silas Martinez is in the room with us tonight. Isaac, I just want to acknowledge you for being here. Thank you for everything you went through, and obviously he's going to be signing autographs in the back. Silas versus Martinez, the dissenting opinion.
Mm-hmm. Okay. Well, John, as they used to say in Shakespeare in Love, that was wonderful. But I want to post a caution. When we had the Trinity case from Missouri, not the Trinity case, but the town of Greece case,
yep.
And we established you can have a serious religious invocation before a legislative assembly. Now, that has created a growth industry for the Satanists in the country. Mm-hmm. And the Church of the Flying Spaghetti Monster, where the ministers coming in with a colander on their heads. And this is what happens when our people, we recognize serious religion, but we're reluctant to recognize any moral grounds for judging the legitimacy of what offers itself to us as religion. Now, the God of the American founders of the Declaration of Independence, the author of the laws of nature and nature's laws, including the moral law, that God did not take a posture of indifference to the affirmation of radical evil. And we have this problem. My friend Sam Alito, in that case you cited in Masterpiece, we say, there is nothing so offensive that it cannot be regarded as legitimate in religion. As you say, it was subjective, which is to say we would rule out the possibility that there could be anything in religion or speech that is offensive in point of principle. Well, Stan Evans used to say the problem with pragmatism is that it doesn't work. And the difficulty for us, if we take the posture of radical moral relativism here, it undercuts the ground on which we want to make a moral defense of religion and make the case for its rightness.
So, point well taken. I mean, charlatanism is a necessary cost that we all bear for the price of religious freedom for all. And sure, there are going to be people that parade at the edges, the radical edges, and test the edges of the ambit of religiosity. I would rather have those people betray the sincerity of their faith over time, ultimately not succeed because of the lack of cogency and gravity and seriousness of their faith, and to have the Supreme Court say, you're not religious because you're a Satanist. There comes a point where the non-judicial process has to be the way of dealing with those questions rather than the judicial process. I think there is a basic sniff test the court insists on. To claim a free exercise protection, one has to be sincere, one has to have good faith, one has to demonstrate that there is a burden or substantial burden on one's faith. And those three criteria do preclude people using the federal courts to press cases that are simply for the sake of parading the absurd. And there increasingly now are also various kinds of frivolous litigation and other kinds of restraints under Rule 11 and other places where folks have said, hey, look, if you're going to use the federal courts basically to play your phenomenological laundry, we're going to have to sanction you. So I do think that's kind of the starting point. I think John's question and your question, however, both raise the harder problem of, look, do we eventually have to have some kind of stipulated definition of religion as a precondition to continued litigation under both the Establishment and Free Exercise Clauses. The founders could not come up with that definition. They recognized there was a difference between religion and non-religion. They talked about those who have no faith, who have no religion, but they didn't define what that ambit is. The Internal Revenue Code is an alternative way of doing it. You have a 15-point checklist, and you have to meet 9 of the 15 before you'll be recognized as a religion. A creed, a code, a cult, a confessional community, and on you go. And you have a kind of phenomenological test. Other states, in dealing with things like tax exemption of church property, say, look, you're going to have something transcendent. It's going to be God or something equivalent to God, something beyond yourself that we have to recognize. We're not going to go through simply, you said so, and we're not going to have the spaghetti monster be your God. It's going to have to be something that's rationally based. I think there's prudence in the prudence in encouraging the court to formulate a better test than it has. We've been waiting a while. The Tricasso v. Watkins case that I indicated in 1961 recognized that there are both theistic and non-theistic beliefs. Sherbert v. Berner in 1963 was the case that introduced sincere and good faith preconditions. It's been a long time that the court has done any more to help us shape the architecture of religion. I do think the democratic process is the better way to go. I do think, however, the court, when it adheres to cases on the Free Exercise Clause as opposed to other constitutional provisions, I think the court would do better to signal some kind of clearer test.
I personally don't, but to ask for it is not sincerity, it's simply a way of smuggling in the moral test from another direction.
I got it. Yep.
And the problem is that in the meantime, we're simply affirming the notion that what Satanism stands as a legitimate strength in this country in the long run that will not be possible.
I think the question is not the legitimacy or illegitimacy of Satanism. The issue is whether Satanism deserves to be recognized as a religion that has a free exercise claim. Even whether they win or lose is another matter. And I think that's the question. And then who makes that judgment about legitimacy and illegitimacy? In my view, of course Satanism is illegitimate. As a Christian, I find that deeply, deeply offensive to be paraded under the guise of religion for what is in many ways simply a show. But the question is whether you want to hand that to a non-democratic process or a non-popular process, and that's a harder one.
Other questions?
Coming to the front.
And that's a fun topic because Judge Newsom recently wrote a concurrence in the 11th Circuit opinion about what is religion. He pontificated that it's really difficult to define. So this is a tough issue. I'm curious about, so Oklahoma recently passed the first religious virtual charter school in the nation. And there's been an establishment clause challenge. So I'm curious, it's a step beyond the Supreme Court cases about public funding for religious education, in the sense that a charter school is defined by state law in many states as a public school. So I was curious if you have thought about this issue, or so specifically public funding of religious schools, and funding the school not just through a program or a rebate or something like that.
That's a good question for John Inazu. Let me try, and I'll come back. So we have this kind of gross disparity initially that we're trying to solve, right? Which is the reality that people have to pay their property taxes in support of local public schools, and some folks do not like what goes on in those public schools, and especially as they become increasingly de-theologized by the Supreme Court in a set of cases from the 1940s to the 1980s. And increasingly, people of faith think, I can't send my kid to the public school. I nonetheless have to pay my taxes to support that public school. And the only way that I can educate my kids in compliance with the mandatory school attendance laws is to send them to the private school or to stay home and homeschool, but I can't afford not to work. And especially for families that are in that middle class bind, they find themselves increasingly not having school choice, and figuring out ways by which we can mitigate that kind of disparity has been the constant challenge over the last 50 years. And we've tried it with tuition tax credits. We've tried it through all kinds of deductions. We've tried it through vouchers and other things. And each of those is a difficult sell, sometimes locally. The recent cases that I mentioned from Trinity Lutheran forward do begin to mitigate things a little bit more by saying those religious schools can, at least for certain kind of matters, be given the same largesse that is given to the public schools. And we have some earlier cases that move in that same direction. But there's still this massive disparity. And the question then becomes, in one's own religious community, and where there may or may not be a religious faith school to which you can send your child, or a faith school is one too expensive for you to be able to afford. Can you have real educational choice when it's basically trying to bootstrap together some kind of education between homeschooling and church schooling and catechesis, or is a religiously founded and managed charter school a better way to go? In my view, it's a good experiment to engage. It's a good experiment to engage in part because it's much better than trying to build another failing public school, of which there are many, thank you very much. We don't need so many more. Number two, it's a more efficient way of doing education than building a straight public school, because many of the religious charter schools that are public schools are going to have support from the religious communities that can't be afforded to the public school, but can be afforded to the religious charter school. Number three, those religious charter schools can be tailored to the distinctive religious demography of the community of which they're a part. And as they become more popular, that I think is going to be an increasingly better way of dealing with pluralism than trying to do a one-size-fits-all or having busing or other kind of things that put folk in place. Fourth, there is an extraordinary amount of talent that has been reserved in the homeschooling movement that now can be tapped in creative ways. And COVID has taught us that, look, we can be adventuresome about how we think about educating our kids. And all manner of folk have come along, many with PhDs in physics and economics and other things, and they have become stay-at-home moms or stay-at-home dads, and all of a sudden there's an opportunity to avail themselves of that talent. This is a good way of doing this direct democracy business that we call the local public school, and I think enhancing things. The dangers, of course, the Establishment Clause dangers are real, right? These cannot be schools that are in the business of catechesis. You can't teach the Baltimore Catechism or the Westminster Catechism or anything else in those schools. That would, in my view, would be too high an Establishment Clause risk or cost to bear in order to have these in place. There has to be some way of segregating the quote-unquote secular and moral and ethical instruction that can properly take place in those schools, and the catechesis and chapel formation and other things that students need as well, that could be adjunct to that school or something outside of the curricular opportunity that students have. Those are my kind of off-the-cuff reflections. John has better ideas.
I don't have better ideas, but two points to complement what you said. One is, doctrinally, this isn't really Carson or Spinoza. This is Zellman. I think the floodgates are open after Zellman, so the doctrine works for a long time in this direction. But what I liked about your answer, John, was you're making kind of policy arguments, which I think underlie a lot of these tricky funding questions. And if at root the policy question is, how do you help undereducated kids get an education? That's a good argument to put in play. It reminds me of the Payroll Protection Act, where pastors received federal funding for their salaries. That's right, a big no-no for James Madison, but we did it 2 years ago. Yeah. So when the funding is framed around a policy need that's urgent, that's for the common good, that's understandable, then sometimes the funding is more permissible. But it's not a black or white legal doctrine. It's a policy question.
Yeah, I mean, we do that all the time, right? I mean, you have a terrible problem with drugs in your community, and you want to create a drug rehabilitation program, and you want to sponsor. Put a lot of federal and state money into sponsoring folk that provide services for those poor folk that are held hostage by drugs and addicts. And well, you can spend all your money building new state institutions and hiring state officials and doing all the apparatus around that. Or you can share the responsibilities with those that maybe well be doing that already in their own private drug rehabilitation programs, whether in the basement of their church and synagogue or as part of a private addiction center. And in my view, when it's for the common good and in service of the community that has needs, let alone something that has to be done because there's mandatory school attendance laws, then the argument becomes, this is easy, this is efficient, right? And as long as you say it's not just the Catholics who can do this, or the Baptists who could do this, or the Methodists who could do this, but anybody and everybody that meets basic criteria, whether religious or non-religious, but private versus public, I would suggest that would be a good thing to do. And charter schools fit into, as John says, charter schools fit into that same mold, in my view. And we've gotten this hermetic, separation idea, with the wall of separation metaphor that Dan Dreisbach said we shouldn't put in, but everybody else says we should put into the education conversation. And I think that's kind of gotten us lost in thinking imaginatively about how to do proper education for everyone.
We do one more quick question, and I'll toss it back to you, John, to finish it up.
Thank you. So this might be a bit of a pivot. By way of introduction, I'm a recent alumna of Emory Law, with the privilege of studying with Professor Witte, also with Professor Rafael Domingo studying canon law, and Professor Abdullahi Anaim on Islamic law, and most of all with Professor Johan van de Vijver, who we all miss very much, and who, more than anyone, was a lodestone on my path to international law and international human rights law. So my question is kind of whither and where the relationship between the Christian legal society and international justice institutions. So today I'm privileged to sit as the inheritor of the Washington Working Group for the International Criminal Court, which was founded by religious individuals. I also serve as the executive director of an organization that includes many faith-based traditions, and we're convened at the moment by the Baha'i. 2 days ago, I was the speaker on behalf of the Coalition for the International Criminal Court and the Coalition for the UN We Need on the Declaration for Future Generations. And there was a missing element of rule of law and whether the legal institutions that we espouse. Today, of course, there was the provisional measures ruling by the International Court of Justice in the case of South Africa v. Israel that brought attention to one of 3 genocide cases of which the court is currently seized. I advocate on behalf of many human rights groups and religious groups for greater awareness of these institutions, the current institutions of the ICJ and the ICC, further institutions of a possible World Court of Human Rights. And so I'd like to hear a little bit more about where you think the Christian legal society could offer value, could offer content, could offer some perspective on this way forward. Thank you.
So Rebecca Shute was one of our superstar students, and you can see that it was wonderful to have her in class because she just kind of ran the class. She was terrific. I'm so proud of all you're doing, and we do miss our dear friend Johan van der Vijver, who was a common mentor to both of us. I can't speak specifically to what the Christian Legal Society per se is doing in the international realm. I'll leave that to our distinguished colleagues and our hosts. And likewise, Trinity Law School that has been co-hosting us so generously. I do think, however, that you point the finger on, you point the spotlight on the reality that religious freedom is not a domestic issue. It's an international issue. It's a global issue. Religious freedom is a universal gift of God to all human beings and to all civilizations, and needs to be joined at the domestic as well as the international level as robustly as possible. David Little, who sits here, was very actively involved in the internationalization of religious freedom norms, the development of the 1978 International Religious Freedom Act and its direct import into U.S. foreign policy, and seeking to measure the religious freedom observance and recognition of foreign nation states, and measuring our own behavior vis-a-vis that same standard was a often sobering kind of reflection. I do think that increasingly as we globalize and borders become more porous and we have co-religionists that are in other countries beyond our own, we have to start thinking very hard about those old measures again, like the International Religious Freedom Act. We have to think hard about our obligations under the 1966 Covenant on Civil and Political Rights. We certainly have to figure out how to make the 1981 Declaration on Religious Tolerance an actual covenant that has binding teeth and does something to implement it in both domestic as well as international policy. I do think the other thing that your comment underscores is the wisdom, forgive me for saying this, for some that have political views to the contrary, the wisdom of learning from others and seeing what the European Court of Human Rights and looking at what other high courts and high judicial courts, high Supreme Courts in other lands have been doing on religious freedom questions. We don't necessarily have a monopoly of or even a prerogative over a lot of religious freedom questions. And as we become more pluralistic, as John says, as we become increasingly open to some of the interesting new dilemmas that have emerged with new religious groups making claims, I think taking instruction, or at least wisdom, or looking at analogies in other high courts and tribunals, I think would be wise for us to pursue. Every country is going to have its own constituents and their own advocates and their own NGOs that do interesting work. John has made clear in some of his publications that religious freedom is not simply something that happens. Religious freedom is always very carefully orchestrated at the high courts and needs to be carefully guided and measured. And the Christian Legal Society, together with a dozen other groups, have kind of dictated the docket on religious freedom questions. And that would be a sobering and important lesson, I think, for folk in other countries to be able to have either as analogies or as outcroppings of what the work that the Christian Legal Society does here. You and I, you were my student, we watched the development of religious freedom in the post-Glasnost Soviet Union and watched, very interestingly, Cantwell and its progeny in the 1940s with the Jehovah's Witnesses pushing religious freedom, the Jehovah's Witnesses again doing the same thing in the former Soviet bloc and helping us develop initially a good religious freedom jurisprudence, which alas has been eclipsed by Putin and his remarkable belligerence.
This has been a really rich discussion. I want to give you the last word, John. We're here with the Christian Legal Society, so maybe one closing word to us as lawyers and one closing word to us as Christians.
So the first word is a word of great gratitude to our friends at the Christian Legal Society, the Trinity Law School, and others who have been so remarkably generous in establishing this forum, setting this beautiful table for us, and having this banquet of both mind and heart and body at once. Secondly, I think it's very important for us as lawyers not to take religious freedom for granted. We used to take it for granted. And as Paul Horwitz says, religious freedom used to be taken for granted, and it no longer is. This is now not a right that you can count on unless it's vigilantly and expertly pursued. Complacency, simple self-interest, failure to have deep expertise is going to be fatal as people of faith, including of the Christian faith, find themselves in increasingly stern headwinds. We cannot be complacent that we have now won the last 10 years and therefore we can sit back and be comfortable. These pendulums swing back and forth, and I think we have to be careful that they don't swing back and hit us. For people of faith, I think the most important reason God gave us religious freedom is for us to discharge the duties of the faith. Religious freedom is there for us to be able to obey the commandments. Religious freedom is there for us to be able to imitate Christ. Religious freedom is there for us to be able to gather in community and to do what is necessary to witness to what Christ has taught us. The Great Commission, all those other commandments that we have, those are really our ongoing responsibility. And we're given religious freedom in order to do that, not in order simply to be living in our own little religious shells. This is probably the old Dutch Calvinist in me that's talking. But the idea of Christ has sovereignty over all things, not just the pew on Sunday or the Eucharist table when we walk up. And I think it's important to demonstrate that sovereignty and to do it with all of the sacrificial love that Christ taught us. End of sermon.
Join me in thanking Professor Witte.
Those of you interested in where CLS may or may not stand on the international religious freedom future, we do have one of the founding fathers of the U.S. Commission on International Religious Freedom with us. He tried to leave CLS a couple of years ago, maybe a decade, 15 years ago, but we pulled him back in, and now he's running the center that Kim Colby used to run for 3 decades. And he is instrumental in the future of our movement when it comes to religious freedom and life. Steve McFarland. Before all of you leave, I would be remiss if I did not bring up one more guest here today. Without them, without their trust, without their purse, we would not be able to be here, and we would not be able to have this event and the future of this event being firmly rooted in their patronage of the vision that we have outlined here today. I want to go ahead and introduce, I believe it would be Dean of Trinity Law School, Eric Halvorson.
Well, on behalf of Trinity Law School, John, thank you so much for your remarks. I found them personally encouraging, but also at the closing piece of your remarks sobering in terms of what our responsibilities are. I want to thank Christian Legal Society, Anton, for your hard work in putting this together. Dave Namo, what you've done. This is truly a partnership between CLS and Trinity Law School, and we look forward to this partnership continuing. This is the first inaugural lecture. There will be many, many more. I was given 15 minutes. May try to finish this in 5, if I can. I do want to take just a moment to recognize some people who've made a long trip out here from California that are a key piece of our little law school that we think punches above its weight and is doing good work. First of all, all 3 are at this table. Myron Steeves is Dean Emeritus of Trinity Law School, and he's been a part of that work there for over 30 years as a professor and also as dean for many, many years. And it's my judgment that he's probably done more to keep Trinity Law School faithful to its founding principles than probably anyone else at that school. Adeline Allen, Professor Allen, is with us tonight. She is well recognized in writing on issues of surrogacy. She's been published in the Harvard Journal of Law and Public Policy and is doing real good work in that and other areas. Adeline was able to be a visiting fellow at Princeton's Madison program several years ago, where she worked with Robbie George. Professor Andrew DeLoach is with us this evening, teaches jurisprudence, constitutional law at Trinity, just completed a sabbatical at the Georgetown Center for the Constitution. I worry about when my professors take sabbaticals because they get recruited, and I don't want them to go away. But Andrew is the director of our Center for Human Rights. And to that last question, Andrew is someone who is a great person to interact with on issues of international human rights. He is the director, as I said, of our Center for Human Rights. He's also professor in residence at our summer program on human rights in Strasbourg. I say this because while I'm proud of their teaching and scholarship, I'm more proud of our professors at Trinity's commitment to deliver a quality legal education, but it's within a framework of a biblical worldview. There are a few schools of law that still do that. There are not many, but there are still a few. We were established 44 years ago on three pillars, three fundamentals: religious freedom, human rights, and the integration of Christianity in the law. And by God's grace, we remain so today. And that's why we're so proud to be honored to sponsor this lecture and these lectures going forward, named in honor of John Witte, whose career is unmatched in teaching, advocating, and promoting these fundamentals and these pillars. May it long continue. And now, if you will, would you bow with me and we'll close in prayer. Father, we are grateful for your presence with us this evening. We thank you for the work of John Witte, for the long career that is still continuing and will continue. We pray for your hand upon him as he continues to do this work. We pray that you would give us all, as lawyers, as non-lawyers, as Christians, the commitment to do the right thing with respect to advocating for religious freedom in this country, for advocating for justice for those who do not have the privileges that we have. We thank you that the work was finished on the cross. We're in a mop-up operation, but it's a tough one. And we ask that you would give us strength and courage and wisdom as we continue to fulfill your will in the law and other professions throughout this world. We pray in Jesus' name. Amen. Thank you very much.